Still rocking the tiny hat. Necktie's a little kerfuffed, but it's all right. All right. Let me go ahead and make sure I tweet out. Rev. Attempting to pass the bar, part 1, twitch.tv/RevScarecrow. Change this to just chatting. There we go. Chat, can we help you cheat? I mean, I'm just studying, to be clear, at this point, for the bar. I'm not actually, like, doing the bar exam right now, but, as in lawyer stuff, yeah, that's why I got a suit on. You can't just do stuff like that without a suit on, right? Here's an example version of the bar exam. Let's go ahead and look over it. Even studying is serious business. Yeah, you gotta dress for the job that you want. The job I want is to basically get a free law degree. Yeah, it says there's no category again. Just chatting. Put that tie on, a little tie. Right. Did I fix it? It should be fixed now. Did I wear the pants too? What was that sound? I'm choking on my tie a bit. Bar exam is not a category. Just chatting is. MBE practice test questions. Get ready for your 2024 bar exam. Perfect. What is the bar exam? Bar exam is an examination administered by each state and territory in the United States by a committee or board of bar examiners. The purpose is to assess whether the candidate, usually a law student graduate, usually but not always, is competent to practice law within that jurisdiction. It's a 2-day bar examination, which is usually given twice a year, the last Wednesday in February to the last Wednesday in July. Bar admission requirements varies from state to state. Passing score is also state-specific. Most states have adopted the UBE, Uniform Bar Exam format. The bar exam is, okay, you got the MBE, which is this is the first time I'm learning any of this. Don't you need education for this? In Texas, you just need to pass the bar. Now, would it be easier if I went to school and, like, learned what the fuck the bar is, rather than learning it from John Keller on this website here? Probably. But, Texas. And then there's the multi-state essay examination, the MPT, which is the multi-state performance. Okay, so the MEE is going to be the one that I'm actually going to fuck up on. How Bar Prep Heroes MBE practice questions helps. This is the MBE, which is the, I guess, multiple choice things. Following practice tests incorporates many of the 7 subjects into hypothetical problem-solving multiple choice questions. Most of the 50 examination practice questions are based on a hypothetical problem. That problem raises a legal conflict between the disputing sides, and that must be resolved through the legal process. You are learning to resolve such fact-based disputes using the proficient legal reasoning and selecting the most likely answer of the 4 alternatives. So, okay. There's only one best answer. Each question has, okay. All right. Let's start the practice test. The sense of frustration associated with a challenging test can backfire. We want you to relax and loose as possible when approaching the material. with a well-rested, flexible, fun-oriented mental state. If you get the wrong answer, in most cases, there is a pertinent statutory and/or case law authority in the explanation. All right. Buyer asked manufacturer to make him 100,000 widgets for $1 million. The buyer intends to retail them by mail order sales. The widgets have had to buyer's imprinted logo on them. Manufacturer ordered the raw material, made a new widget mold that contained the buyer's logo. The buyer wanted a quick delivery of at least 10,000 right away. The manufacturer rushed the order and sent 10,000 conforming widgets 2 days later. The buyer paid for the widgets, but rejected delivery on the remaining 90,000 widgets. What is this? There are channel memberships now on YouTube. They do not give you access to the Discord. It's been available for me to do it that way for a bit, but I could not get it to work. And with the number of people who are having issues with the way that Twitch things are changing, specifically if you live in the EU, so on and so forth. Manufacturer filed a suit claiming damages for breach of contract. The defendant buyer filed a motion to dismiss the complaint on the basis that the statute of frauds was violated in that it was a contract for over $500 was unenforceable under state law. Would the court likely grant the motion to dismiss? Oh, there's no contract. They didn't have a contract for this? So they just bought them. I'm a paralegal, so ask me anything. Oh, I don't know anything. Okay. The opposite of ask me anything. Don't ask me anything. All right, well, I mean, common sense says that, like, if you tell them to make a thing, you ought to pay for it, but that's not always how the law goes. So, also, because they had to rush them, they were not of the quality they were supposed to be. Yes. Fuck! No, because the exception is the goods were made specifically for the buyer. Okay. A man was emotionally upset due to marital problems, voluntarily checked into a private medical facility for treatment. State law provided that if he tried to leave against medical advice, the hospital could hold him for 72 hours while trying to convince him to stay. During this day, he told medical providers that he was intensely angry at his wife, who was living with another man, and he wanted to harm her. Despite that knowledge, the hospital issued him an unrestricted weekend pass. When he got out, he shot and killed his wife. Man's children sued the hospital for negligence. The hospital filed a motion to dismiss, mainly because there was no privity with the descendant and no duty owed to her. Well, no, because the hospital is strictly liable for releasing patients that it knows I mean, I don't know if it's a 1. I mean, like, I know that if you say you're going to kill someone in, like, a psych thing, or that you did kill someone, or you committed a crime in a psych evaluation, I have a associates in psychology. That they have to, like, let the police know. Yes, because the intervening acts of third parties are unforeseeable and cannot rise to liability. Yes, because there's no duty to control the conduct of another person and prevent that person from harming others. No, because the special relationship and control between the doctor and the inpatient mandates a due to care by the doctor to prevent foreseeable danger to others. No, because the hospital. I think it's this one. Fuck. Where the treatment of mental patients involves an exercise of control by a physician who should know that the patient is likely to do bodily harm to others. An independent duty arises from that relationship, requiring the doctors to exercise reasonable care to prevent harm. Yeah. I picked the wrong one. I got that one right. A homeowner buys a new leaf blower and is so impressed with its power that it gets carried away and blows a large amount of his work into his neighbor's yard. In addition to the leaves, he also blew mounts of pest-infested plant debris into the neighbor's property. The material has accumulated into a large, unsightly piles and caused damage to the neighbor's healthy plants. And that's to pay the workers to haul the materials away and incur expenses to replace the infected perennials. The neighbor sues for tort of trespass. The homeowner files a motion to dismiss because the neighbor cannot prove that the homeowner acted with the intent to trespass or do harm. Well, there's general nuisance laws. Pitmaster Stein, thank you for the 10, or the raid. No, because the trespass is based on intentional act of entering the land or sending something onto the land. An actor does not have to intend harm. Yeah, that one. Yeah, we got one. Welcome, Raiders. Were you streaming something as well, Pimpmaster? Although trespass is an intentional tort, the tort does not require proof of the intent to trespass or intent to cause harm. Yeah, if you just, like, end up trespassing on accident, that doesn't matter. Hello, my name is Blank. Thank you for the 25 months of support. First time going through Earthbound. That is a long-ass stream you've set yourself up for. It's a good one. Luigi Guy is, like, currently, I think, working out how to get overseas. So, probably doesn't have the ability to do that right now. Also, like, I'd have to set it up every time. Not a bounty. Predictions. Start prediction. Okay. What's the answer? 1, 2, 3, and 4. Okay, I'll do that on the next one. Although trespass is an intended tort, the tort does not require proof of proof of intent to performing the act that leads to the trespass is all that is needed. So you were intentionally doing stuff. With trespass causing something to go onto the land without personal intrusion by the defendant, thus the intention to blow the leaves is all that's needed here. Harris County versus Cypress Forest Public Utility Distribution is the case law. Okay. Cool. Next question. College student attending a fraternity party. Okay, I'm going to go ahead and start the prediction now because there's this stuff down here. College student attended a fraternity party. he noticed a young woman flirting with him in a sexually suggestive way. He took her home, ended up forcefully raping her. This is a fun thing to do, isn't it? Reading about this. She escaped after the rape and went directly to the authorities. The police filed charges of rape. The student defendant found several men willing to testify the woman was promiscuous, had relations with her, and that she was very prolific in her sexual life. Will the trial court likely permit the witness to testify the woman's predisposition? No. Yeah, rules of evidence prevent, yeah. You can, I mean, in Texas, maybe yes. Anasi, thank you for the 49 months of support. If I am a criminal, like a serial bank robber, right? And I rob all of the banks. Doesn't matter if I robbed all of the banks in the world except for yours. It only matters whether or not I robbed yours for it to be a thing on whether or not I committed a crime in that one specific case. I can't be tried under the idea that, like, yeah, so she could have lived having sex with all these other guys, and maybe she decided at the last minute, no, it should be no. Okay. I don't even give a shit that I got that one wrong as long as the answer was no. The exception is where evidence of previous acts would bear directly into the defendant's innocence. Evidence in a rape victim's chastity relating to her sex life in general, whether or not the testimony concerning her general reputation or testimony concerning specific acts with other persons is ordinarily not prohibitive either under the general creditability of a witness or the consent to write. Answer 4 is not correct because the rules do not try to keep prior sexual history out of the victim, but there are very limited areas where, okay, fair. Can the bet time be longer? Sure. Sorry about that. So the correct answer was 3. Let's read it first, and then we'll do what do you guys think the answer is. A property owner agreed to sell one of his real estate parcels to his neighbor, earn up the agreement of sale with the sale price of $200,000. He signed the document, the neighbor took it, and returned with a bank check for the full amount, demanding that the deed be tendered. Property owner then decided that the terms were not reasonable, and he returned the money and refused to tender a deed. The neighbor sued for specific performance, and the property owner defended on the basis that the neighbor did not accept the agreement's terms and did not sign the document. The neighbor sued for the specific performance of the transaction. Is the court likely to rule in favor of the neighbor? Okay. There we go. Predictions are now available. No, because they didn't accept that they agreed to the thing. No, because the neighbor had to put his signature on the document to make it a binding contract. Yes, because the neighbor manifested an asset by his conduct of tendering the full sale price, at which point the contract existed. And yes, because the property owner created a binding contract, which he prepared an agreement containing the agreed terms. Should he have to sell his property, even though the other guy did not sign it yet? I would say yes, because this would count almost like a verbal agreement, right? Yeah. The neighbor's actions are in conformance with the offer, which in this case, our payment and written agreement combined with the property owner's offer and signature in writing are consistent with the statute of frauds, enough to make it a binding contract. Like, he did everything leading up to it being like, except for sign it. Like, did he really need to sign it? The correct answer on that one was 3. Well, I think the verbal agreement can be proved in this case because the guy gave him a check. Do you guys need more time on your predictions? Which class of lawyer are you specking into? I don't know. Whatever I feel like. Thank you for the 83 months of support, Ego. A man who was reportedly a renowned art thief was on trial for stealing several Picassos from a museum. The paintings had been recovered and were in the courtroom. The prosecutor presented a professor of art history to authenticate each piece. The defense objected on the basis that the museum curator where the paintings were housed had to identify if these were in fact the paintings that were stolen, assuming to others will testify to the fact of the burglary. Is the court likely to reject the witness as being qualified to authenticate the paintings in questions? Why or why not? So before I actually get it so you guys can, you know, get your points. Yes, because the artworks and other physical evidence must be authenticated by an official custodian. Yes, because an outside person may be able to partially authenticate the paintings, but he can't say whether or not that one was in the museum was the one that was stolen or not. No, granting the objection will simply waste the court's time if the court has to bring in a museum curator to go through the hoops to authenticate the paintings. No, because the authentication can be accomplished in several different ways that will verify the genuine piece of... I mean, really, the question is... Like, wouldn't it be more important whether or not it was the thing they actually stole or not? Submission period is going to be 1 minute. There we go. Yeah, it doesn't really matter if it's the authentic one, right? It matters whether or not it's the painting itself. I think it's 2, right? We're just checking to see if it's the real deal or not. So I feel like 2 works because it's not saying whether or not it's the same thing. God, that's like such a weird scam you could do. You could hire someone to steal a painting, then switch out the painting that they stole with a fake, then get them in trouble. Then it turns out that they don't have the real one, which means that the museum doesn't have the real one. And then you find the real one. And then you go, I have the real one, actually. Maybe a couple years later. I'm going to go with yes. Motherfuck! Grant's answer was 4. The details of the burglary were covered by other tests. Yeah, you didn't need him. I'm never going to get to be a lawyer at this rate. I don't know what the fuck I'm doing. Being a lawyer's hard. It's like you have to go to school for it or something. Some homeless people started residing on a strip of land located under a bridge. The land was owned by a nearby chemical manufacturer, and the squatters did not ask for permission, and the company did not feel it was an urgent problem. The squatter used a small lake on the property for bathing and drinking. Within a few days, the squatters died from what later revealed to be a highly polluted water coming from the company's waste discharges. The company knew that it had waste discharges. The estates of the two descendants sued the company. Will they likely prevail on their tort claim despite the company's defense that the descendants were trespassers? Believe this will be squatters' laws. Yeah. I mean, yeah, it's, again, I don't know if this counts as like the Texas thing or not. All right. Yes, because they were trespassing, they had a duty to warn. So they knew that they were there. I think I've heard of cases where people broke into places and then they got hurt while they were in there. I think this is the same as booby trapping your house, yeah. And they knew the squatters were there. They had an opportunity to say something about it, do something about it, get the squatters out. They should have put up a sign or something, being like, yeah, this water's fucked. Your Honor, the water sucks. I'm getting the reason wrong, which is going to make the essay portion really fucking hard. In common law, negligence requires a duty which has been violated. As a general rule, no duty is owed to a trespasser except to refrain from acting with wanton and willful disregard. The owner knows the trespassers and knows about the dangerous conditions. I'm getting the right answer, but I'm picking the wrong answer. Does that make sense? An elderly man died with a will that had the following clause. After payment of such debts, hold on, and funeral expenses, I give and bequeath my beloved wife the farm on which we now reside and all my personal property so long as she remains a widow. The wife retained the property and did not remarry. Some years prior to her death, she conveyed a deed in fee simple to her oldest son. After her death, her youngest son filed a claim against the estate, contending that his father's will devised only a life estate to his wife. State statute said that the fee simple would be presumed where the intent of the testator did not clearly show an intent to devise a lesser estate. Unofficial mic raid. You just finished at the zoo? Well, welcome, everybody. I'm attempting to get good at the bar exam. I got my tiny hat, got my suit. We're doing this. Lower court held that the widow had received a defensible fee conditioned on her remarrying a widow. Because she did not remarry, the deed to the son ripened into an indefeasible fee absolute at the time of conveyance, and the younger son applied. Do you actually want to be a lawyer, or is it just for fun? I assume the latter. So in Texas, you don't actually have to go to school to get good to be a lawyer. You could just like win. Like if you just pass the bar, you're good. So like I'm practicing to take it. Now, it is like $600. Am I actually going to, you know, go through the trouble of doing this for the bit? Maybe. But basically just for the bit. Should a fundraiser stream for the bar exam? What if you leave state, though? I mean, I'm going to come back and see my folks, you know, drop by in like July or February, probably February, to get around the snow in Maine, and then get pass the bar exam, you know? Forklift certification would be easier. You could probably do that online. Okay, so, and I'm doing, all right. Yeah, we could just get random certifications. Lockpicking, forklift certification, first aid certification, CPR training, lawyer, Lord of Sealand, Reverend, Traitor to America. Just worthless fucking things to be, you know, good at. Excluding the lawyer thing is kind of okay. You can still work on cases from Texas out of state. That's true. Is there a certification for Traitor to America? I mean, I just got called that by someone. I decided to take that as a badge of honor. You could still count as a pope. A Discordian pope, but still. Yeah. Dude, if I get to be a lawyer, I could make a fucking advertisement for it. I could be like, here, hold on. Were you injured in a lawsuit? Do you need your money now? Do you need a reputable lawyer? Fucking good luck with that shit. I'm just here. I'm a lawyer. Have you been hurt? Good. Do you want to get married? Do you want to get divorced? Does your neighbor think that they should have lawn flamingos, but you hate them? Call me, and I'll cuss you out, you stupid son of a bitch. Anyway, what was the question? Right. So the man gave the thing. Okay, got it. Okay. Okay. Manage prediction. All right. So which of these answers do you think it is? One, yes, because the life state that ends on her remarriage or death with a remainder over to all the sons. Yes, okay. Yes, the deed could not convey more than a life estate because the condition in the will. No, because the will devises a simple fee that was defensible if she had remarried. Well, she wasn't allowed to remarry, right? Yeah. No, the deed superseded anything that was stated on the will because she was still alive when she conveyed the title. Oh, she wasn't dead yet. Well, she didn't get married. So, wouldn't... Yeah, she would lose the property if she remarried. I'm going to say No, the deed superseded anything that was stated in the will because she was still alive when she conveyed it. Motherfucker! Being a lawyer is too hard. No, because the will devised a simple fee that was defensible if she had remarried. Yeah, that. Rev, fun-oriented and flexible mindset. Absolutely goddamn not. Like, I say the reason, but I'm not picking the right answer. This is why I did horribly in school. Because I'll say the right thing, but then not actually, like, get it right. Regulation prevents people with a drug arrest and or conviction and or those undergoing current treatment for drug abuse from working in a certain state-runs facilities for the safety of the general public. Okay? All nurses are now fired. One employee of the Department of Treasury brought a action claiming a denial of equal protections due to the process taking away his right for a job. Second guess yourself? Okay. Strat, don't answer the same as Rev. What is this clip? Injured in a lawsuit. Do you need your money now? Do you need a reputable lawyer? Fucking good luck with that shit. I'm just here. I'm a lawyer. Have you been hurt? Good. Do you want to get married? Do you want to get divorced? Does your neighbor think that they should have lawn flamingos, but you hate them? Call me, and I'll cuss you out, you stupid son of a bitch. The hat makes it better, 100%. A regulation prevents persons with a drug arrest and conviction and or those undergoing... Okay, right. It was claimed that the prohibition is necessary to protect the public from potential problems that could arise. Which test of constitutional validity would be likely applied in this regulation? Okay, right. I recognize some of these terms. I'm going to read over them. Strict scrutiny, since drug users are a special class of person often discriminated against by the public. I don't think that drug users are a protected class. Intermediate scrutiny, because like gender, this can be a sensitive area where discrimination is common. Rational base testis, because discrimination is generally favoring with drug users or even those getting... Or rational base test, because regulation need only be related to legitimate state interests to be valid. Okay, I'm going to put the prediction up, but I think I know what my answer is. And I'm not going to say my answer, because if I say it, then you guys will be like, not that one then. Because Rev doesn't know what the fuck he's talking about. I believe judges can oversee marriages. Do you need a lawyer? I'm not a good one. I haven't even passed the bar. Give me money. You have to shout. Your resume just says 41 out of 40. I think that it's just rational basis. Yeah! Let's fucking go! I'm gonna be a lawyer in no time! Rev, what are your charges? I don't have much. I can pay you in snacks and cat photos. Okay.
You are a very special boy.
Rational basis test is used to review laws and statutes that do not impact a suspected class or suspect class and do not directly burden a fundamental right. While the right to work is fundamental, the right to work at a given place as a government or state employee is not considered a fundamental right. A pet breeder is in the business of breeding calves at his cattle ranch, where he has a stable of prolific cows who are very fertile. These cows like to fuck. Do you have sexy cows that want to get bred? Do your cows want to fuck like rabbits? Don't call me. It's a fucking weird thing to call someone about. Just keep that shit to yourself, my dude. One day, one of the employees inadvertently leaves the fence door open, and a newly born calf breaks free and goes onto his neighbor's land. The breeder went to the neighbor's land to retrieve the calf for its safety to make sure it was unharmed. However, he was arrested for a trespass charge after entering the land. The breeder appealed, but the court dismissed the charge. Go ahead and bring up the prediction thing again. Yes, because he had limited privilege to enter the land to prevent harm to his chattel. Yes, because the tender pet doctrine allows temporary entry to retrieve baby animals. No, because he had the right to keep any living chattel that crossed onto his land. No, because his status as a breeder made him unqualified for a limited license. I'm not taking notes. You kidding me? What does fertility have to do with this? I don't know, he just has a shit ton of cows? So, okay, here's what I know about cow law, which is not much. Cows have, like, weird amounts of rights. You're allowed to, like, go onto someone else's property to save their cow if it's upside down, for example. Like, you won't be charged for that. So I'm gonna go with this, because otherwise, if a cow goes onto your property, be like, yeah, I can't get your cow, or I can't get my cow because it went onto your property, so that's why I just let it run amok and destroy all your shit. Answer 1 is the best choice for this under these answers. Yeah, exactly. Because it would be stupid if you just, like, let cows just run free because they broke out of their enclosure. It makes no goddamn sense. Skriddle has got 6 out of 10 so far. Under reinstatement 19.7, a person is privileged to enter or remain on land in the possession of, if it is reasonably appears to be necessary to prevent serious harm to or the actor or his land or the cattle. Answer 2 is correct because there is no tender pet doctrine. Exactly. Okay. Skriddle is their name, yeah. I like how the cow entered my land. The cow is mine now. That works with frisbees, I think, but not cows. A painter working for a construction company. There's a tender years doctrine in common law. I see. Three was some biblical shit, for sure. What is this test about? This is the bar exam. Well, it's a test for the bar exam. I'm prepping for the bar. I'm gonna become a lawyer. Do I have any right to do so? No. Is it a stupid fucking bit? Yes. Are you a cow that's been injured while on a work site for construction? Cow tools. A painter working for a construction company was working with a group of construction co-workers on a house construction when a section of the house fell down on the owner. The painter declared, "I knew they should have reinforced the standing wall better than they did. It's all their fault." It turned out he was referring to his co-workers employed by the same construction company. The owner filed suit for damages against the construction business. He tried to put the statement from the painter onto the evidence, but the defendant objected. Well, the court sustained the company's objection to the admission of the painter's statements. Yes, because the painter is not qualified to make such statements regarding non-painting duties. Yes, because the painter is not a participant as a negligent party in the catastrophic mistake that occurred. No, because the painter worked for the same company as the negligent workers and his statements were within the scope of the course of his employment. No, because the painter may testify as a subcontractor to what he observed on the location. Cow law. We're passing the bar. Can I stop for a drinky? Yeah, sure. Cow tools, cow law. Did it hurt when you fell from heaven? Sue God! I can't help you with that. Actually, I can because I'm a reverend, and I think that's what I'm allowed to do. Call me now, and we'll figure that shit out. All right, chat's got their answers in, so I'm going to put this one. Motherfuck. Why is the fourth one not correct? 4 is not correct because the painter was not described as a subcontractor. Oh, yeah, he was not described as a subcontractor. That's right. That's right. I made assumptions. You know what they say about assumptions? Ass. Next question. A pet store owner opened up a store in a new town. She was not aware that city council had recently passed a law prohibiting the sales of cats and dogs from a retail pet store. Statute had a provision that allowed the pet store to be given space, to give space to a nonprofit humane society to adopt animals from the store. This is pretty common. The owner sued the city in federal court, claiming the violation of due process and equal protection of the 14th Amendment. Okay. The court used the rational basis test to conclude. I'm sorry, hold on. Yeah, no, that is the right law. Okay. I didn't think the 14th was the right one for that. But it is. 14th Amendment is they can't make laws or enforce any law that shall abridge the privileges or immunities of citizens of the United States. The court used the rational basis test to conclude the statute served a legitimate state interest and was enforceable. The pet store owner appealed the decision. Will the appellate court likely affirm the lower court's decision? Yes, because the pet store owner was not treated any differently than any other pet store owner. Yes, because the correct test requires only the law in question will satisfy any set of facts that could establish a rational basis for achieving legitimate government ends. No, the pet store owner has vested constitutional right to earn a living and unreasonably conclusion by the law in question. No, because the ordinance is so individualistically discriminatory that it must pass the scrutiny test, which it fails to do. Okay. I think I know the answer on this one. I'm pretty sure I got the answer on this one. I am like 90% certain. And the 10% chance that I'm wrong, I'm pretty sure I'm getting wrong because I picked the wrong one of the two. You know what I mean? Is the law preventing you from earning money? Do you want to sell crack cocaine? Do it, champ. We need some more of that shit out on the street, and I need my fix. Call me now. I need cocaine. What are these bits? These are what lawyer ads are like in America. Like, legitimately, they're just kind of like that. Just shouting. Here, hold on. Here's one from Houston.
Pretty when you face a bad truck wreck. Greedy insurance companies play dirty. Bring it on. I'm Jim Adler, the Texas Hammer.
Go at them with Jim Adler, the tough, smart lawyer that knows how to beat them at their own game.
I stand tough and carry a big, big hammer. I thought so.
Call now, 713-777-4000, or learn more at jimadler.com.
That's just how American lawyer advertisements are. America Explain. He's got a big hammer and he's going to use it. All right. Yes, because he was not treated any differently. And that's the 10% right there. The correct test requires only the law in question will satisfy any set of facts that could establish a rational basis for yeah. Okay. Yeah, a majority of y'all picked the wrong one too. State Constitution says in one state guaranteed the right to marry a same-sex and opposite-sex couples alike. Political group got a proposition on the ballot. A majority of the people voted.
What is that? It's the end of.
No. Okay. Eliminate the right of same-sex couples. Majority of the people voted to eliminate the right of same-sex couples to marry. Proposition does not affect any other rights that same-sex couples have or may have possessed from existing state law. Persons affected sued the government for unconstitutionality of taking away the rights that they had no legitimate purpose in violation of the Due Process Clause of the 14th Amendment. Will the court grant the request of the lawsuit and declare the proposition void to reinstate the rights of the same-sex couple's right to marry? Yeah, I did hear that the unknown got hired onto a different thing, which is great. You know, everyone in that deserves to get hired. Okay, so here are our options. Start prediction. Yes, the due process clause, no compelling state interest justifying denying same-sex couples the fundamental right to marry. Yes, because under the 14th Amendment, would be illegal to interfere or illegal interference against the right of privacy guaranteed to everyone. No. Because the people voted to take a provision out of an already existing constitution where it was done by a public vote, it cannot be altered. Or no, because the ballot proposition was properly placed on the ballot and all statutory procedures were followed, thus precluding the courts from taking adverse action. Hold on. Do you need a lawyer? I have 36 years of experience of being alive. I don't know what the fuck being a lawyer's like, and I probably won't pass the bar, but I'll see your case.
You are a very special boy.
Frames look sharp on me? Yeah, they're for distancing. I don't really need to wear them while I'm inside because, like, it's not that far to my computer screen. It's like a arm's distance. Okay, I believe that being gay is considered a protected class, which means that it does end up denying them a basic right. So I believe the answer is yes, and for this reason. Good. A vested constitutional right cannot be taken away by a majority vote of state voters. Makes me wonder how Texas banned abortions. Suck my nuts? Texas has no idea what the fuck it's doing. Like, legitimately, it just does not. It just does things. I actually have no idea how that is supposed to be valid. I would say that it's unconstitutional, but our Supreme Court sucks ass, so who knows? I guess it is constitutional. Texas hates itself and hates women. Hey, speaking of, give me a second. You guys want to look at Pornhub? Dear user, as you may know, your elected officials in Texas are requiring you to verify your age before accessing our website. While safety and compliance are at the forefront of our mission, providing identification every time you want to visit an adult platform is not an effective solution for protecting users online, and in fact will put minors and your privacy at risk. So basically, I'm not allowed to use Pornhub. Why am I on Pornhub now? Because I'm allowed to see Pornhub. I'm not allowed to stream Pornhub. Nothing a VPN can't fix. Yeah, there was a massive increase in VPN searching in Texas the day that got switched over. Next question. He's getting more fucked and Puritan here. Yeah. I mean, it's not the reason we're leaving, but I need to get out of Texas so I can look at porn again. Do you want to jerk off, but the government says no? They can't stop you. Do it anyway. Get a VPN, jerk your dick until it's raw, and call me in the morning. I'm not a doctor. I don't play one on TV. I don't even know why I brought that up. Lawyer. You're allowed to own guns but not watch porn. Well, you can. They didn't make Pornhub illegal. They just made it so that way you have to provide an ID if you want to use it, which the government could later subpoena, being like, hey, we've decided being gay is a crime now. So, like, we need to know everyone who was jerking it to gay shit. So, like, it's not currently illegal to look at gay porn. But it's Texas, so I would not be surprised if it heads that direction at some point. I want to hear a lawyer argue it's not gay to jerk it to gay porn. I mean, that... I'm in North Carolina, yeah. A witness sees a murder in a park and is called to testify in a criminal case. Can the defense attorney ask her on cross-examination about her habit of feeding pigeons? The defense knows that she was cited several times for illegally feeding pigeons. The defense counsel tries to ask, you have a long-time habit of feeding pigeons, don't you? You, in fact, have been ticketed several times for feeding pigeons, haven't you? And yet you persist in doing it. Isn't that so? Will the trial court likely allow this question to be questioned on these matters? No, because the question has a probative value regarding the credibility of the witness or the guilt of the defendant. What? Why would that be no? No, because a witness can never be asked about their personal prior bad acts. Yes, because the statements indicate the witness's intention. Yes, because feeding the pigeons in the park and persisting in it after ticketed may show an antisocial trait in the witness. Do you live a life? Fuck, hold on. Do you live a life of debauchery, feeding pigeons in the park? Are you antisocial enough to just murder someone there? Do you like murder and feeding pigeons? Fucking based. Call me now. I just want to know more about you, you weird fucking freak. Oh, what was the answer on the last one? It was 1, right? I'm just going to delete the prediction and return everyone's points because I don't remember what the answer was and I don't want people to lose points over it. Start prediction. What's the answer? Okay, go. Vote. No, because the question has no probative value regarding the credibility of the witness or the guilt of the defendant. No, because the witness can never be asked about their personal prior bad acts. Yes, because the statement indicates that witness's attention is always focused on feeding pigeons. Yes, because feeding pigeons in the park after persisting in... Okay. I expect 4 because it's the dumbest option. The law is not quite this stupid, I don't think. Like, because that's like implicating them in a crime by saying you committed one crime, so why wouldn't you murder someone? Well, thank you, Crin Thief. You're looking very, Esquire to your Reverend. Very base qualification completionism. Completionist run. All titles. I'm going to become king and emperor one day. Despite the fact that I am super against monarchy. I just gotta go for it, you know? Alright, I'm gonna say no because it has no probative value. Like, literally, what the fuck are you talking about? Sit up? Okay, sorry. Also, hi, sweet heart. Are you home? Because I think I heard you come home. I don't see why pigeons are relevant. Pigeons are relevant only sometimes. You're only against the monarchy because you're on a monarch. Yeah. Thank you for the wife shrimp check. I love you. It has no relevance to the murder case and would be far removed collateral matter that would disrupt the flow of the trial for no good reason. Yeah. Is he wearing a suit? Goddamn right I am. Holy fuck, there's so many questions. 20 mistakes are allowed. Am I wearing a suit bottom? The world may never know. Business person sent his employee an administrative assistant to represent him at a conference where the business deals are negotiated. The principal gave the assistant all the materials to set up the table with the principal's cards, brochures, promotional materials, price lists, and even some order forms with the business person's logo on them. It's easier to become a lawyer than it is to beat Christopher Robin. You need a 60% to pass? I'm guessing sweatpants? Could be. In addition, the assistant represented to third parties that she was officially representing the principal, that she was authorized to execute contracts on his behalf. The assistant negotiated a deal for the business person with third party, which the business person refused to honor because he did not like the terms that were negotiated. Will the third person likely prevail in enforcing contract against the business person? Yes, because furnishing a indica of authority to act to the employee was sufficient proof to bind the principal. Yes, because the principal is bound to the employee's actions whether he sends an employee to attend to the convention on his behalf. How many of you are hotter right now so far? I'm a little bit warm, I'll be honest. I don't think that was your question, but I'm a little bit on the warm side. No, because dealing with an assistant at a convention have a duty to determine whether or not that person is in fact an authorized agent. No, because the technological revolution makes it easy these days for a potential customer to first confirm the existence of an actual authority. Suits make everything hotter? Super hot. Super hot. Okay, everyone's done their thing. I mean, I'm going to say 3 because I don't think that this person was actually sent there with that in mind. Like, they just kind of were sent there. Right? Okay, yeah. That's the first one that I got, like, super wrong. I almost went with yes, but I said no. How are y'all doing? How many of y'all are lawyers at this point? A man is sitting on a beach chair peacefully and in a relaxed meditative state when a truck racing on the sand ran down a sunbathing elderly person. Man said out loud, "Oh God, look what that truck driver did." The man driving that truck was racing and going about 100 miles per hour. Someone called 911. A man who was sitting on the beach nearby but facing the other way heard the man's outcry. When the case comes to trial, will the court allow both the man and the women to testify about the man's utterances? Phoenix Wright does like Japanese law, and it's also anime Japanese law, so it's like not relevant to American law. Yes, both the man and the woman can testify because it's the excited utterance exception to the hearsay rule that goes to the material issue of the case. Yes, because it's not hearsay, and it both being entered into the truth of the statement by either witness can say they both testify. No, because neither of them can testify because the man was impaired due to being in a relaxed from his meditation. Woman cannot repeat utterances of an impaired. Well, hearsay is a rule. But I don't think it has anything to do with this shit. Well, you can have a bench trial, also known as a bitch trial. KJB, thank you for the 22 months of support. I will never pronounce your name correctly. There's no way Rev just dabbed in 2024. Yeah, it didn't happen. You got no fucking proof. I'm a little confused about who's yelling. Is it the person who's getting run over or just the man? Is dabbing back? It's absolutely not back. But like jeans, I'm going to keep it in style until it's good again. I thought Simple Flips was trying to become a psychologist, not a lawyer. The man meditating said it, yeah. It's the excited utterance thing. Oh, so many people got that shit wrong. Psychologists are just brain lawyers. What an insane take. I love it. An owner of a pizza and Italian food restaurants opens a new location on a street where another owner has a burger restaurant. It seems the business is slow for the pizza place owner, as he eyes up his competitor, the burger man, as the reason. The pizza owner starts making false statements about the burger restaurant and its inferior ingredients, which he says have been causing protein poisoning in some customers. Glass Brain, thank you for the 112 months of support. Holy shit. Did you know in most of Europe the emergency number is 112? I did not. When the burger joint owner loses customers and business income to the pizza place owner, can he sue for conversation? Star prediction. Yes, because the pizza owner interfered with his right of peaceful enjoyment and business, disrupted his business activities. Yes, the conversion is an intentional tort. The pizza owner acted intentionally to convert and did not convert part of the business. No, because the conversion consists of appropriating another person's property. No, because there was no interference with the ownership or right of possession of his personal property. I don't really feel like this is the thing you should be doing. Like, this is not... Shouldn't this be, like, liable instead? Did someone try talking to you? Did they say, girl, you just need to smile and that'll make you look pretty? Sue them. For what? I don't know. Fuck them, though. Call me. I'm gonna go with 1, but I don't think this is right. I have a question. Doth thine bussy be poppin'? Okay, yeah. Wouldn't this case be about liable instead? Hello. Hi, cute stuff.
Do you need water?
Yes, please, my love. You're cutie. Your Honor, thine bussy be poppin'. We're focusing on whether or not the I mean, yeah, but I don't feel like that these are the reasons you could sue them. Welcome back, Luigi guy. I'm gonna say yes on this. Good luck on your travels, Luigi guy. Hopefully you're not taking a Boeing. Because apparently they just explode now. I think they've probably been like that for a while, though. So I think we're probably getting, there's a name for that in the news. Thank y'all. Oh, I was talking about other stuff. All right, I'm going to go with yes. How much Google can we use? None. That's cheating. You think you get to use Google on There are 100,000 flights every day. Yeah, I don't think that there's that many. You don't get to use Google when you go on the bar. Your answer is correct. No, it wasn't. No, I got that wrong. What? Okay. The president and sole stockholder of a small business negotiated to sell the business to an individual investor. The parties met and signed a letter agreement, which set forth a price, down payment, amount, financial terms, the assets to be included, and a host of other pertinent details. The final closing date was not stated, but the purchasers left a down payment of $20,000 with the sellers. Letter stated that the terms comprise their essential agreement, but the formal document would be drafted by the parties' attorneys. Before that happened, the seller returned the check and refused to perform. The investor brought an equity action for a specific performance to compel the sale. Nice. Equity court ruled that there was a complete and binding contract that must be specifically performed, while the appellate court likely affirmed the lower court's decision. Bitch, I don't even understand what the fuck this question is. So it feels very similar to that one we answered earlier, where they just like, they tried to buy a thing, and then they gave them the money, and they're like, never mind. Now, who's doing it? Oh, okay. So the seller backed down after the buyer paid the $20,000, but is this your new poo ball? It could be. No, because the closing date was left out and the attorneys were supposed to compromise or compose the final contract with all the remaining details put in. No, because the type of letter is generally a gentleman's agreement and is not intended to be legally binding. Yes, because the letter of intent is legally binding and sets forth a price, describes the business, and is signed by both parties. Yes, where the letter contains all the essential required terms for the contract, it will be enforced as a Michael in the DMs. Hold on, I gotta boot up Discord again because Discord keeps closing out on me. Forced again tonight? When about? Whenever I'm ready. Well, I'm trying to pass the bar. We could do that. I think I want to eat probably before I do that. So like, yeah, like let's get to at least question 20 or so, right? Hit me up when you inevitably fail the bar. Listen, dude, I've got my suit on. I like that this is probably the easiest part of the bar exam because you don't have to write stuff. It's just multiple choice. Did it have everything it needed? I mean, I feel like that's a yes, right? Yeah, because it's the same thing as the other one. Field versus Golden Triangle Broad. Yeah. Answer 3 is incorrect because it's an incomplete statement of what would be needed to express the essential terms. For example, mere description of the business tells us nothing about the terms of sale, terms of payment, and the specific nature and identification of the assets that to be transferred to other similar details. Got it. Oh shit, this one's about weed. Let's fucking go. A vehicle operator was driving on the highway at night. His girlfriend was in the passenger seat and they were returning from a college night class. She was smoking marijuana and blowing it out an open window, but not sharing it with the driver. The driver fell asleep, causing the car to veer off the highway and go into a ditch where it landed upside down. Both the driver and the passenger were seriously injured. She sued the operator for negligence. The operator filed a counterclaim asking for damages against the passenger by arguing that the passenger was herself negligent by smoking weed and causing him to fall asleep. Is the court likely to grant the passenger's motion to dismiss the counterclaim? Yeah, it's basically, that's how I remember this, Shadow, is because that's exactly what happened with Elon. You ain't getting high from someone else smoking. You absolutely can if you're kind of hotboxing it. Yes, because the passenger... Okay, will they dismiss the counterclaim? Yes or no, and explain your answer. Not the weed thing, the previous thing. Yes, because the passenger was not actively participating in a joint enterprise. Nice. And did not do enough to contribute to cause the accident. Yes, because the vehicle operator is always liable and the passenger cannot be made liable for the driver's actions under any circumstances. No, because the driver has properly alleged that a joint enterprise has where the passenger is liable for her share of the negligence in causing the accident. No, because the passenger was breaking the law, making her negligent per se. I'm going to go with yes. Because you are responsible for being in control of your vehicle. And if it was distracting, he should have pulled over. Passenger may be found liable for injuries to others in an accident if the passenger's conduct substantially encouraged or assisted the driver's negligence, since there's no possibility of that given the facts. They're both involved, though. Why? Because she wasn't driving. She wasn't, like, messing with the wheel or anything. It was his job to stay awake. It was not her job. All right, last question, then we switch things up and we hang out with Mike. She chemically attacked him. That's a nice argument. I'll see you in court. If I get this one right, then it's a 50-50. An elderly woman was mugged and robbed in public street. At the time of the offense, the victim only saw her assailant's eyes. A hooded sweatshirt bandana concealed the rest of his face. A few days later, while the victim waited to be interviewed, she observed the defendant being escorted through the courthouse in jail clothing and restrained by handcuffs and leg irons. She identified him as a perpetrator shortly after. Will the court allow that identification into evidence? The prediction answer was 1, by the way. Oh, right. Sorry. And the answers here are no, because it is not reliable enough and there's too much suggestion to make a reasonably accurate identification. No, because the prior statements and identification are considered hearsay and never allowed in evidence. Yes, because the witness perceived the perpetrator by seeing his eyes and made the identification based on that basis. It was reliable enough to be admitted. Yes, because the witness recognition of someone is all that's needed. The reliability or credibility is subject to cross-examination. Is it even legal to bet on bar exams? I don't know. Maybe. I'm not a lawyer. You think I know anything about this shit? Yet. Yeah, yet. It's true. Yet. I'm curious on what, really, you guys actually thought it was, oh, okay, yeah, no, I agree with you, it is 4, because, like, that's not good evidence, but, like, that's something for the court to, like, figure out in cross-examination. Alright, I guess I'll go fuck myself, I don't know a goddamn thing. No, because it's not reliable enough. I mean, yeah, it really should not be considered, right? Winner was 1. Alright, yeah, no, fuck this. I'm not becoming a lawyer anytime soon. 11 out of 20 suck my nuts, RevScarecrow. You suck my nuts. I got 9 out of 11. '41 out of 40. Suck my nuts, Christopher Robin. Yeah. Anyway, give me a minute. I only saw his eyes. I feel like they should allow that and just be like, bruh, you're old. And he had, like, how the fuck do you know that it was him? I don't know. I mean, I guess it makes sense to not even let that in, right? I'm gonna check and see if there's any art. Because now's a good time to look at it.
What is that? It's the dog.
Objection, Your Honor. Objection, Your Honor. This is fucking stupid. And she's dumb and old and honestly gonna die, so honestly, what does it fucking matter at this point? Like, she's just gonna die anyway. You really want to fuck up his life because she's so old and useless? Like, maybe he needed the money. What if he did it and it was based?
You are a very special boy.
11 out of 20 is 5% off the 60%. Your Honor, if she wanted that money so bad, why did she lose it? Seems like she didn't really give a shit about it. You know? It's basically just money lying on the sidewalk. Because she's old and she's gonna lie on the sidewalk one day. When I knock her the fuck out after this trial. I rest my case. Alright, hold on. Here's some art that was sent by Reefs and Relaxation. Let's go ahead and pull that up on screen real quick. Read Luigi Guy's one? What did Luigi Guy say? Your Honor, my client is based until proven cringe. He's gotta riz up that bitch with the gyat. Rev should do streamer court? I have no idea how I get involved in that. Your Honor, how do we even know this lady even had the money? For real, no cap. Just saying. So anyway, here's some art. They said, hello, Rev. I've got some fart to share. Shoutouts to Count Cannoli for helping me realize that I can send it to you in this way. Made Rev Snufkin per Tilda's request. Yeah, you can always submit art to me on Tumblr. That works too. In chat during the first Snufkin Melody of Moomin Valley stream, he's telling off some hooligans for disturbing the peace in a graveyard, an homage to one of my favorite stories of yours. Second picture is of you and Tilda turned into Tove Janssen style trolls. I'd like to think the two of them get around by riding on the backs of cats. That's amazing. Hope you can find some joy and reasons to smile with all the recent chaos. Thank you for your streams and inspiring art and creativity, and for being yourself. Appreciate you, Rev. Well, I appreciate you. Thank you. Look at these arts. We got this first one of me in the graveyard with a knife as Snufkin. Awesome. And then we got this one of me and Tilda hanging out as little fellas. This is very fella-coded art. It's very good. Thank you so much for this. And thank you, Count Cannoli, for encouraging them to do this by posting in this way. Post your art. Send me art, man. It makes me feel special inside. Post your art about me somewhere and send me links. I need to see them. And pictures of your cats, or I'll sue. Rev derangement syndrome. Yeah, all right. So I need to get set up with that. Give me a couple minutes to do that, and I might see about food and stuff like that. Give me 2 minutes, and I'll let you guys know how it's going. And then we might end up doing the thing with Mike immediately, or I might go and eat. So 2 minutes. BRB. Rev, please. I only have $4. Too bad. You're sued. Should have thought of that before you didn't send me cat pictures. Alright, I am back. Chat means cat. Well, there you go. Alright, I am back and ready to go. Yeah, I don't think I'm going to pass the bar anytime soon. You scared me. I forgot your stream was on. Well, that's what you get for forgetting. Do not forget to res/clone Kevin's. I think we're going to just, like, keep... Like, maybe do a new run, because... I mean, our base kind of is in a shitty place. So, does it matter? We're just sort of waiting for him to message me back at this point. Well, if we just start a new run, then the woman comes back too. I'll talk to Mike about it. We'll see what he we'll see what he thinks. 6 is the usual time. Well, what are we gonna do for like 13 minutes? It's like, hey, do you want to do this? Whenever you're ready. All right. Jail? You guys want to do some jail time? What's on my mind? Nothing really. Just ate some granola bars because I was all on the hungry side. One rousing game of Boltaro. Yeah, Baltro is pretty short, I guess. I've done a couple runs off stream. I got one deck completed. We'll just do this until he comes back. How's that sound? I'll flick the switch for the people on After Hours, so just be aware this is happening. 3, 2, 1, rep.